verdict of the day was the fact that the Supreme Court has backed SEBI by rejecting the transfer of the Adani-Hindenburg case to the CBI. It also gives the regulator 3 months to conclude its probe and allow it to examine the need for regulatory changes as well as any violations of the norms in short selling by Hindenburg. My colleague Ashmit Kumar spoke to senior advocate Sidharth Luthra on his assessment of the case. Here's what he had to say.
I would say,
yet to be taken
as
to the
regards
logical
the 20 instances which have been investigated, the fact that there is an exoneration is a shot in the arm for the Adani Group. As regards to that, investigation will take place, and whatever its conclusions will have to be considered by the court at the appropriate stage and a view taken. That we will have to await.
So just one word as far as the SEBI regulations are concerned. There were questions raised about the existing framework. To that end, Supreme Court very clearly has held that there is no dilution of FPI norms, rather they've been tightened. Does this perhaps give an indication of the current framework in place, or more work needs to be done? Expert committee regulations also need to go into?
As of today, the Supreme Court has appreciated the work that has been done and has therefore said that nothing further needs to be done on the regulations. In any case, the Supreme Court does not sit over a legislative exercise, which is the domain of SEBI, and that is what they have said. Having said that, in my view, keeping in view the changes in technology, keeping in view the changes in the ways of doing business, there is always need for regular upgradation of regulations, because that is the whole purpose of having delegated legislation, so the government can keep adding and making robust mechanisms to ensure that transactions and the regulatory mechanism is strong, robust, and the interest of investors is protected.
One final question, sir, on the question on the credibility of Hindenburg report, OCCRP report. Supreme Court has had some very stern observations to make that it can be only supplementing the investigation. It cannot satisfy being concrete proof.
In every mechanism, in every nation, there are regulators which operate, and once the Supreme Court has given a vote of affirmation to the functionality of SEBI as also to the regulatory mechanism, clearly the report of SEBI has to have precedence over any private reports. It is important that when private investigations come, that those may be looked at, but since SEBI has now, I would say, put a quietus to the whole issue, the matter stands resolved.
Okay, all right. That is all about the Adani Hindenburg case and some expert opinion coming in there as well. But let's go back to other stock-specific action that we are tracking. GAIL is